They changed my locks while I was still inside. I want you to understand what that sentence means before I say anything else. Not evicted, not given notice, not asked to leave. I was sitting in my room on the second floor of a shared house in Leeds at 11:30 on a Wednesday night, and someone turned a key in the front door that was no longer my key. And I want to tell you about the thing that happened in court, the thing I did not see coming, the thing that nobody saw coming. But I cannot tell you that yet. You need to know what they took from me first. My name is Callum. I was 20 years old when this happened. Second year of a geography degree at the University of Leeds. I had 4 housemates and people I barely knew, strangers assembled by the letting agency into a 5-bedroom Victorian terrace on a street that smelled of chip fat and cut grass, depending on which way the wind was blowing. The house had thin walls and a boiler that groaned every morning at 6. My room was at the back. It faced a small garden that nobody used. I paid £580 a month for it. The letting agency was run by a man named Gerald. He had an office on a high street I passed every time I walked to the library, and a manner that I can only describe as formally dismissive. The tone of someone who has decided before you have finished speaking that whatever you are saying does not count. He managed 17 properties in the area. I know that number now. I did not know it then. The trouble started in October, a leak in the ceiling above my desk. I reported it by email on the 9th. I have the timestamp. Gerald acknowledged it 12 days later and said a contractor would be in touch. The contractor was not in touch. I chased 3 more times. By November, the damp patch above my desk had grown to the size of a dinner plate and the plaster had started to bubble. I put a bucket on my desk when it rained. I have a photograph of that bucket. I have a photograph of everything, and that matters more than I can tell you right now. I stopped sleeping properly in November, not because of the leak exactly, but because of the anxiety the leak represented. Every time it rained, I would lie awake listening for the drip. The sound of water hitting plastic at 2 a.m. is something I still hear sometimes when I close my eyes. I started missing lectures. My concentration collapsed. By December, I had seen a university counsellor twice and been referred to my GP, who recorded anxiety and low mood in my notes. I was not okay. I want to be honest about that. I was not okay at all. This is the moment I want to stop and ask you something, because I think it reframes everything you just heard. The question is not whether the letting agency were negligent. They were clearly negligent. The question I want you to hold is this: why did they respond to a maintenance complaint by deciding to get rid of me instead of fixing the ceiling? Because that is what they did. And the answer to that question tells you something important about how certain landlords and letting agencies think about students specifically. In December, Gerald sent a letter to all 5 tenants. It stated that the tenancy agreement contained a clause 11, subsection 3, allowing the agency to terminate with 4 weeks' notice if a tenant was found to be in breach of the property maintenance obligations. The letter claimed I'd caused the damp through improper ventilation of my room, not the leak in the roof. My behaviour, my fault. I called my mum that evening. Her name is Margaret. She answered on the second ring, the way she always does, and I heard the particular quality of silence she produces when she is frightened, but trying not to sound frightened. She drove 3 hours from Harrogate the following Saturday. She brought sandwiches, proper ones, not supermarket, and sat at my desk in my damp room and read every piece of paperwork I had while I made tea on a kettle that took 8 minutes to boil. She did not cry until she was back in her car. She told me that much later. Margaret found a citizens' advice drop-in session in Leeds city centre. We went together on the Monday morning. The advisor there, a man named Stuart, took one look at Gerald's letter and said 4 words that I have not forgotten. This is not legal. He explained. A Section 21 notice, a no-fault eviction notice, requires 2 months minimum notice, must be on a specific prescribed form, and cannot be served if outstanding maintenance issues have been reported and not resolved. Gerald's letter was not on the prescribed form. It gave 4 weeks, and we had 9 documented maintenance reports. His notice was invalid on 3 separate grounds. But Gerald did not wait for the legal process. The night of the 22nd of January, a Wednesday, 11:30, I heard footsteps on the stairs, heavy ones, not any of my housemates, and then a sound I did not immediately understand. A key in the lock of my room door, not the front door, my room. The door opened, and a man I did not recognize stood in the doorway holding a locksmith's case and looking at me with an expression of moderate surprise, as if I was the unexpected element in this situation. Behind him was Gerald. Gerald told me I had until the morning to remove my belongings. What he had done is called illegal eviction. It is a criminal offence under the Protection from Eviction Act 1977. You cannot change a tenant's locks without a court order. You cannot enter a tenant's room without permission. You cannot use intimidation or harassment to force a tenant to leave. Gerald had done all three in the space of approximately 4 minutes. I called Margaret at midnight. She drove through the night. Now, here is the thing I have been withholding. Here is the fact that changes the shape of this entire story. The locksmith Gerald had hired was registered. He had a company name, a business address, a paper trail, and he had not wanted to do the job. He had said so in writing, in a text message to Gerald 3 days before the eviction, stating that what Gerald was describing sounded like an illegal eviction and that he would need written confirmation from a solicitor that the action was lawful before he proceeded. Gerald had replied with 4 words, "I'll sort it out." No solicitor confirmation ever came. The locksmith showed up anyway, but he kept the messages. Margaret found a housing solicitor named Fiona through a law centre in Leeds. Fiona filed a claim in the county court under the Protection from Eviction Act and the Housing Act. She also pursued a claim for damages and distress, anxiety, the disruption to my studies. We had medical records, we had the counsellor's notes, we had 9 maintenance emails and 3 photographs of the damp patch and 1 photograph of a bucket on a desk. We had Gerald's 4-week letter. And we had now a locksmith who was very unhappy about the position he had been placed in. The hearing was in March, a Tuesday. The courtroom was smaller than I'd imagined, with fluorescent lighting that made everyone look slightly ill. Gerald's solicitor argued that the eviction had been a misunderstanding, a miscommunication between Gerald and the locksmith, that Gerald had believed the tenancy had already legally ended, that he had acted in good faith. And then Fiona called the locksmith. His name was Trevor. He sat in the witness box and answered Fiona's questions in a flat, careful voice, as if he had decided before entering the room that he was going to say exactly what happened and nothing else. He produced the text messages. He read them aloud. He confirmed that he had expressed concern about the legality of the eviction. He confirmed that Gerald had told him it would be sorted. He confirmed that no legal confirmation had ever arrived. He confirmed that he had proceeded anyway, and that he regretted that. Gerald's good faith argument collapsed in approximately 7 minutes. The judge ruled in my favour on the illegal eviction. Gerald was ordered to pay £8,400 in damages covering distress, disruption to my academic year, and a punitive element reflecting the seriousness of the eviction itself. The maintenance claim was partially upheld. The claim for the full loss of my academic year was not. The judge accepted that my anxiety predated the eviction and that causation for the full academic impact could not be established beyond the relevant standard. A partial win. That is what Fiona called it. £8,400 and a ruling that what Gerald did was criminal. Not nothing, not everything. The detail I want to return to now is Margaret at my desk, reading paperwork, in a damp room with a bucket on the desk and a boiler groaning through the floor. I think about that image often. This woman who drove 3 hours each way twice and asked for nothing and said everything by doing it. Because here is what I know now that I did not know then. Gerald had done this before, at least twice, according to other tenants who came forward after the case. He had calculated that students in particular would not have parents who drove through the night and sat in citizens' advice offices at 9 in the morning. He had calculated wrong once. £8,400 arrived in my account. I passed my second year. I finished my degree. My anxiety is better. Not gone. Better. But here is the part I cannot fully resolve for you, because I cannot fully resolve it for myself. The academic year claim that was rejected, the judge's finding that causation could not be established. There is a version of this story where the ceiling gets fixed in October and none of the rest of it happens, where I sleep through November, where I do not sit in a counsellor's office twice a week feeling like I am coming apart. I believe Gerald's negligence caused that. The court did not fully agree. That thread is still loose. I do not know what to do with it. And there is something else I have not told you yet. Something about Gerald and the 17 properties and what happened after the judgment that made everything more complicated and more interesting. That part is coming, but this story was already long enough for one sitting. What I want to leave you with is a question. If you were in that room at 11:30 with a stranger in your doorway and your landlord behind him and your mum 3 hours away and a second year of university hanging in the balance, what would you have done? Because I nearly didn't call her. I nearly just started packing. And sometimes I think about all the students who did.